Republic Act No. 9775. An act defining the crime of child pornography, prescribing penalties therefor, and for other purposes. Be it enacted by the Senate and House of Representatives of the Philippines in Congress assembled. Section 1. Short title. This act shall be known as the Anti-Child Pornography Act of 2009. Section 2. Declaration of Policy. The state recognizes the vital role of the youth in nation building, and shall promote and protect their physical, moral, spiritual, intellectual, emotional, psychological, and social well-being. Towards this end, the state shall a. Guarantee the fundamental rights of every child from all forms of neglect, cruelty, and other conditions prejudicial to their development. b. Protect the child from all forms of exploitation and abuse including, but not limited to: 1. The exploitative use of a child or children in pornographic performances and materials. And 2. The inducement or coercion of a child to engage in, or perform any sexual activity or practices, through whatever means. And c. Comply with international treaties to which the Philippines is a signatory, or a state party concerning the rights of children, which include, but not limited to, the Convention on the Rights of the Child, the Second Optional Protocol to the Convention on the Rights of the Child on the Sale of Children, Child Prostitution and Child Pornography, the International Labour Organization, or ILO, Convention No. 182 on the Elimination of the Worst Forms of Child Labour, and the Convention Against Transnational Organized Crime. Section 3. Definition of terms. A. Children refers to persons below 18 years of age, or those over, but are unable to fully take care of themselves, or protect themselves from abuse, neglect, cruelty, exploitation or discrimination, because of a physical, or mental disability or condition. For the purpose of this act, a child shall also refer to: 1. A person, regardless of age, who is presented, depicted, or believed to be a child as defined herein. And 2. A computer-generated, digitally, or manually crafted images, or graphics of a person, who is represented, or who is made to appear to be a child, as defined herein. B. Child pornography refers to any public or private representation, by whatever means, of a child engaged in real or simulated explicit sexual activities, or any representation of the sexual parts of a child for primarily sexual purposes. C. Child pornography materials refers to the means and methods by which child pornography is carried out. 1. As to form. First, visual depiction, which includes not only images of real children, but also digital image, computer image, or computer-generated image, that is indistinguishable from that of real children engaging in an explicit sexual activity. Visual depiction shall include: A. Undeveloped film and videotapes. B. Data, and/or images stored on a computer disk, or by electronic means capable of conversion into a visual image. C. Photograph, film, video, picture, digital image, or picture, computer image or picture, whether made or produced by electronic, mechanical, or other means. D. Drawings, cartoons, sculptures, or paintings depicting children. Or, E. Other analogous visual depiction. Or, second, audio representation of a person, who is, or is represented as being a child, and who is engaged in, or is represented as being engaged in explicit sexual activity, or an audio representation that advocates, encourages, or counsels any sexual activity with children which is an offense under this Act. Such representation includes audio recordings, and live audio transmission conveyed through whatever medium, including real-time internet communications. Or, third, written text or material that advocates or counsels explicit sexual activity with a child and whose dominant characteristic is the description, for a sexual purpose, of an explicit sexual activity with a child. 2. As to content. First, it includes representation of a person who is, appears to be, or is represented as being a child, the dominant characteristic of which is the depiction, for a sexual purpose, of a. The sexual organ, or the anal region, or a representation thereof. Or b. The breasts, or a representation of the breasts, of a female person. D. Explicit sexual activity, refers to actual or simulated. 1. Sexual intercourse, or lascivious act including, but not limited to, contact involving genital to genital, oral to genital, anal to genital, or oral to anal, whether between persons of the same, or opposite sex. 2. Bestiality. 3. Masturbation. 4. Sadistic or masochistic abuse. 5. Exhibition of the genitals, buttocks, breast, pubic area, and/or anus. 6. Use of any object or instrument for lascivious acts. E. Internet address, refers to a website, bulletin board service, internet chat room, or news group, or any other internet, or shared network protocol address. F. Internet cafe or kiosk, refers to an establishment that offers, or proposes to offer services to the public for the use of its computer, or computers, or computer system for the purpose of accessing the Internet, computer games, or related services. G. Internet content host, refers to a person who hosts, or who proposes to host Internet content in the Philippines. H. Internet service provider, or ISP, refers to a person or entity that supplies, or proposes to supply, an Internet carriage service to the public. I. Luring, refers to the act of communicating, by means of a computer system, with a child, or someone who the offender believes to be a child for the purpose of facilitating the commission of a sexual activity, or production of child pornography. J. Grooming, refers to the act of preparing a child, or someone who the offender believes to be a child for a sexual activity, or sexual relationship by communicating child pornography. It includes online enticement, or enticement through any other means. K. Primarily sexual purposes, refers to purposes which will fulfill all the following conditions. 1. The average person applying contemporary community standards, would find the work taken as a whole appealing to prurient interest, and satisfying only the market for gratuitous sex and violence. 2. The work depicts or describes sexual conduct in a patently offensive way. And 3. The work taken, as a whole, imbued within its context, manner or presentation, intention and culture, lascivious, literary, artistic, political, and scientific value. Section 4. Unlawful or prohibited acts. It shall be unlawful for a person to commit any of the following acts. A. To hire, employ, use, persuade, induce, or coerce a child to perform in the creation, or production of child pornography. B. To produce, direct, manufacture, or create any form of child pornography and child pornography materials. C. To sell, offer, advertise and promote child pornography and child pornography materials. D. To possess, download, purchase, reproduce, or make available child pornography materials, with the intent of selling or distributing them. E. To publish, post, exhibit, disseminate, distribute, transmit, or broadcast child pornography, or child pornography materials. F. To knowingly possess, view, download, purchase, or in any way take steps to procure, obtain or access for personal use child pornography materials. And G. To attempt to commit child pornography by luring, or grooming a child. Section 5. Duties of an Internet Service Provider, or ISP. An ISP shall a. Prevent access or transmittal of child pornography materials by any person, and shall install a blocking system to prevent access to such materials. B. Within 7 days, report the presence thereof, as well as the particulars of the person maintaining, hosting, distributing, or in any manner contributing to the Internet address, to the proper authorities. And c. Preserve such evidence for purposes of investigation and prosecution by relevant authorities. An ISP shall, upon the request of proper authorities, furnish the particulars of users who gained, or attempted to gain access to an Internet address which contains child pornography materials. An ISP, who shall knowingly, willfully, and intentionally violate this provision shall be subject to the penalty provided under Section 13(e) of this Act. Section 6. Duties of an Internet content host. An Internet content host shall a. Not host any child pornography on its Internet address. b. Within 7 days, report the presence of child pornography, as well as the particulars of the person maintaining, hosting, distributing, or in any manner contributing to such Internet address, to the proper authorities. And c. Preserve such evidence for purposes of investigation and prosecution by relevant authorities. An Internet content host shall, upon the request of proper authorities, furnish the particulars of users who gained or attempted to gain access to an Internet address that contains child pornography materials. An Internet content host who shall knowingly, willfully, and intentionally violate this provision, shall be subject to the penalty provided under Section 13(e) of this Act. Section 7. Duty to provide blocking system or software. The following shall also have the duty to install blocking system or software to prevent transmittal of or access to the child pornography materials. A. Internet cafe establishments. B. Private and public educational institutions. C. Public and private offices. And d. Service providers, such as telephone companies and others. Section 8. Duty to report. Photo developers, information technology, or IT, professionals, credit card companies, and banks, and any person who has direct knowledge of any child pornography activities, shall have the duty to report any suspected child pornography materials, or transactions to the proper authorities, within 7 days from discovery thereof. Section 9. Facilitating unlawful or prohibited acts. It shall be unlawful for a person to knowingly facilitate the commission of any of the prohibited, or unlawful acts under any of the provisions of this Act. Section 10. Providing venue for commission of prohibited acts. It shall be unlawful for a person to knowingly, willfully, and intentionally provide a venue for the commission of prohibited acts, such as, but not limited to, dens, private rooms, cubicles in Internet cafes, cinemas, secluded areas in residential houses, or in establishments purporting to be a legitimate business. Section 11. Confidentiality. The right to privacy of the child shall be ensured at any stage of the investigation, prosecution, and trial of an offense under this Act. Towards this end, the following rules shall be observed. A. The judge, prosecutor, or any officer of the law to whom the complaint has been referred to may, whenever necessary to ensure a fair and impartial proceeding, and after considering all circumstances for the best interest of the child, conduct a closed-door investigation, prosecution, or trial. B. The name and personal circumstances of the child, or any other information tending to establish his, or her identity, shall not be disclosed to the public. C. Any record regarding a child, shall be confidential and kept under seal. Except upon written request and order of the court, a record shall be released only to the following. 1. Members of the court staff for administrative use. 2. The prosecuting attorney. 3. Defense counsel. 4. The guardian ad litem. 5. Agents of investigating law enforcement agencies. And 6. Other persons, as determined by the court. D. Any child pornography material that is part of the court records, shall be subject to a protective order that provides as follows. 1. Child pornography materials may be viewed only by the parties, their counsel, their expert witness, and guardian ad litem. 2. No child pornography material, or any portion thereof, shall be divulged to any other person, except as necessary for the investigation, prosecution, or trial. And 3. No person shall be granted access to the child pornography material, or any part thereof, unless he, or she signs a written affirmation that he, or she has received, and read a copy of the protection order, that he, or she submits to the jurisdiction of the court with respect to the protective order, and that in case of violation thereof, he, or she will be subject to the contempt power of the court. And e. In cases when prosecution or trial is conducted behind closed doors, it shall be unlawful for any editor, publisher, and reporter, or columnist, in case of printed materials, announcer or producer, in case of television and radio, producer and director of a film, in case of the movie industry, or any person utilizing the tri-media facilities or information technology to cause publicity of any case of child pornography. Section 12. Common Penal Provisions. A. The penalty provided under this Act, shall be imposed in its maximum period, if the offender has been previously convicted under this Act. B. When the offender is a corporation, partnership, or association, the officer or employee thereof, who is responsible for the violation of this Act, shall suffer the penalty imposed in its maximum period. C. When the perpetrator is an ascendant, parent, guardian, step-parent, or collateral relative within the second degree of consanguinity, the perpetrator thereof, who is responsible for the violation of this Act, shall suffer the penalty imposed in its maximum period. D. The penalty provided for in this Act, shall be imposed in its maximum period, if the offender is a public officer or employee, provided, that if the penalty imposed is reclusion perpetua or reclusion temporal, then the penalty of perpetual or temporary absolute disqualification shall also be imposed. E. Any attempt to commit any of the prohibited acts under Section 4 hereof, shall be punished by a penalty 2 degrees lower than that prescribed for the consummated acts. F. If the offender is a foreigner, he, or she shall be immediately deported after serving his, or her sentence, and be barred permanently from entering the country. G. In all cases, any person found guilty of providing venue for the commission of prohibited acts under Section 4 hereof, shall be treated as a principal, and penalized as such. H. Any person found guilty of facilitating the commission of any prohibited acts, shall be punished with a penalty 2 degrees lower than that prescribed by the offense. I. Any business establishment used in the commission of the prohibited acts provided herein, shall be immediately closed, the authority, or license to operate cancelled, without prejudice to the forfeiture of the proceeds and investments, and without prejudice to the prosecution of the owner, president, managers, or responsible officer, who participated in the commission of the offense, or who shall knowingly permit, or fail to prevent its commission. Section 13. Penalties and Sanctions. The following penalties and sanctions are hereby established for the offenses enumerated in this Act. A. Any person found guilty of violating Section 4, A, B, C, and D, of this Act, shall suffer the penalty of reclusion temporal in its maximum period, and a fine of not less than 1 million pesos, but not more than 2 million pesos. B. Any person guilty of violating Section 4, E, shall suffer the penalty of reclusion temporal in its minimum period, and a fine of not less than 500,000 pesos, but not more than 1 million pesos. C. Any person found guilty of violating Section 4, F, shall suffer the penalty of prison mayor in its maximum period, and a fine of not less than 300,000 pesos, but not more than 500,000 pesos. D. Any person found guilty of violating Section 4, G, shall suffer the penalty of prison mayor in its medium period, and a fine of not less than 100,000 pesos, but not more than 300,000 pesos. E. The owner, head, president, partner, manager or responsible officer of any ISP, or Internet content host, who shall knowingly, willfully or intentionally fail to perform his, or her duties under Sections 5 and 6 of this Act, shall suffer the penalty of prisión correccional, and a fine of not less than 50,000 pesos, but not more than 100,000 pesos. F. Any person found guilty of violating Section 8 of this Act, shall pay a fine of not less than 30,000 pesos, but not more than 50,000 pesos. G. Any person found guilty of violating Section 11, e, hereof, shall suffer the penalty of arresto mayor in its maximum period, and a fine of not less than 30,000 pesos, but not more than 50,000 pesos. Section 14. Who may file a complaint? Complaints on cases of child pornography and other offenses punishable under this Act may be filed by the following: A. Offended party. B. Parents or guardians. C. Ascendant or collateral relative within the third degree of consanguinity. D. Officer, social worker, or representative of a licensed child-caring institution. E. Officer, or social worker of the Department of Social Welfare and Development, or DSWD. F. Local Social Welfare Development Officer. G. Barangay Chairman. H. At least 3 concerned responsible citizens where the violation occurred. Or I. Any person who has personal knowledge of the circumstances of the commission of any offense under this Act. Section 15. Venue. A criminal action arising from a violation of this Act shall be filed where the offense was committed, or where any of its elements occurred, or where the child is found, or actually resides at the time of the commission of the offense, provided that the court where the criminal action is first filed shall acquire jurisdiction to the exclusion of the other courts. Section 16. Authority to regulate Internet cafe or kiosk. The local government unit, or LGU, of the city or municipality, where an Internet cafe or kiosk is located, shall have the authority to monitor and regulate the establishment and operation of the same, or similar establishments in order to prevent violation of the provisions of this Act. Section 17. Legal protection to victims of child pornography. The child who is a victim of child pornography shall be recognized as a victim of violent crime, defined under Section 3(d) of Republic Act No. 7309, or an act creating a Board of Claims under the Department of Justice for victims of unjust imprisonment or detention and victims of violent crimes, and for other purposes so that the child may claim compensation therein. The child and family shall be entitled to protection, as well as the rights and benefits of witnesses under Republic Act No. 6981, or the Witness Protection, Security and Benefit Act. Section 18. Mandatory services to child pornography victims. To ensure recovery, rehabilitation, and reintegration into the mainstream of society, concerned government agencies and the LGUs shall make available the following services to victims of child pornography. A. Emergency shelter or appropriate housing. B. Counseling. C. Free legal services, which shall include information about the victim rights, and the procedure for filing complaints, claiming compensation, and such other legal remedies available to them, in a language understood by the child. D. Medical or psychological services. E. Livelihood and skills training. And F. Educational assistance. Sustained supervision and follow-through mechanism that will track the progress of recovery, rehabilitation, and reintegration of the child victims, shall be adopted and carried out. Section 19. Confiscation and forfeiture of the proceeds and instruments derived from child pornography. In addition to the penalty imposed for the violation of this Act, the court shall order the confiscation and forfeiture, in favor of the government, of all the proceeds and properties derived from the commission of the crime, unless they are the property of a third person not liable for the unlawful act, provided, however, that all awards for damages shall be taken from the personal and separate properties of the offender. Provided, further, that if such properties are insufficient, The balance shall be taken from the confiscated and forfeited properties. When the proceeds, properties and instruments of the offense have been destroyed, or diminished in value, or otherwise rendered worthless by any act or omission, directly or indirectly, of the offender, or it has been concealed, removed, converted, or transferred to prevent the same from being found, or to avoid forfeiture, or confiscation, the offender shall be ordered to pay the amount equal to the value of the proceeds, property, or instruments of the offense. Section 20. Programs for Victims of Child Pornography. The Interagency Council Against Child Pornography, created under Section 21 of this Act, shall develop and implement the necessary programs that will prevent child pornography, as well as protect, heal and reintegrate the child into the mainstream of society. Such programs shall include, but not limited to, the following. A. Provision of mandatory services including counseling, free legal services, medical, or psychological services, livelihood and skills training, and educational assistance to the child pursuant to Section 18 of this Act. B. Sponsorship of a national research program on child pornography and other acts covered by the law and the establishment of a data collection system for monitoring and evaluation purposes. C. Provision of necessary technical and material support services to appropriate government agencies and non-governmental organizations. D. Sponsorship of conferences and seminars to provide venue for consensus building amongst the public, the academe, government, non-governmental, and international organizations. And E. Promotion of information and education campaign. Section 21. Interagency Council Against Child Pornography. There is hereby established an Interagency Council Against Child Pornography, to be composed of the Secretary of the DSWD as chairperson and the following as members. A. Secretary of the Department of Justice, or DOJ. B. Secretary of the Department of Labor and Employment. C. Secretary of the Department of Science and Technology. D. Chief of the Philippine National Police. E. Chairperson of the Commission on Human Rights. F. Chairperson of the Commission on Information and Communications Technology. G. Commissioner of the National Telecommunications Commission. H. Executive Director of the Council for the Welfare of Children. I. Executive Director of the Philippine Center for Transnational Crimes. J. Executive Director of the Optical Media Board. K. Director, National Bureau of Investigation. And L. 3 representatives from children and NGOs. These representatives shall be nominated by the government agency representatives of the Council, for appointment by the President for a term of 3 years, and may be renewed upon renomination and reappointment by the Council and the President, respectively. The members of the Council may designate their permanent representatives, who shall have a rank not lower than Assistant Secretary or its equivalent, to meetings, and shall receive emoluments as may be determined by the Council in accordance with existing budget and accounting rules and regulations. The DSWD shall establish the necessary secretariat for the Council. Section 22. Functions of the Council. The Council shall have the following powers and functions. A. Formulate comprehensive and integrated plans and programs to prevent and suppress child pornography. B. Promulgate rules and regulations, as may be necessary for the effective implementation of this Act. C. Monitor and oversee the strict implementation of this Act. D. Coordinate the programs and projects of the various member agencies, to effectively address the issues and problems attendant to child pornography. E. Conduct and coordinate massive information dissemination and campaign on the existence of the law, and the various issues and problems attendant to child pornography. F. Direct other agencies, to immediately respond to the problems brought to their attention, and report to the Council on the action taken. G. Assist in the filing of cases against individuals, agencies, institutions, or establishments that violate the provisions of this Act. H. Formulate a program for the reintegration of victims of child pornography. I. Secure from any department, bureau, office, agency or instrumentality of the government or from NGOs, and other civic organizations such assistance, as may be needed to effectively implement this Act. J. Complement the shared government information system relative to child abuse and exploitation, and ensure that the proper agencies conduct a continuing research and study on the patterns and schemes of child pornography which form the basis for policy formulation and program direction. K. Develop the mechanism to ensure the timely, coordinated and effective response to cases of child pornography. L. Recommend measures to enhance cooperative efforts and mutual assistance among foreign countries through bilateral, and/or multilateral arrangements to prevent and suppress child pornography. M. Adopt measures and policies to protect the rights and needs of the victims of child pornography who are foreign nationals in the Philippines. N. Maintain a database of cases of child pornography. O. Initiate training programs in identifying and providing the necessary intervention or assistance to trafficked persons. P. Initiate training programs in identifying and providing the necessary intervention or assistance to victims of child pornography. Q. Submit to the President and the Congressional Oversight Committee created herein the annual report on the policies, plans, programs, and activities of the Council relative to the implementation of this Act. And R. Exercise all the powers and perform such other functions necessary to attain the purposes and objectives of this Act. Section 23. Extradition. The DOJ, in consultation with the Department of Foreign Affairs, shall endeavor to include child pornography among extraditable offenses in future treaties. Section 24. Congressional Oversight Committee. There is hereby created a Congressional Oversight Committee, composed of 5 members from the Senate, and 5 members from the House of Representatives. The members from the Senate shall be appointed by the Senate President based on the proportional representation from the parties or coalition therein, with at least 1 member representing the minority. The members from the House of Representatives shall be appointed by the Speaker, also based on proportional representation of the parties or coalitions therein, with at least 1 member representing the minority. The committee shall be headed by the respective chairpersons of the Senate Committee on Justice and Human Rights, and the House of Representatives Committee on Justice. The Secretariat of the Congressional Oversight Committee shall come from the existing Secretariat personnel of the committees of the Senate and the House of Representatives concerned. The committee shall monitor and ensure the effective implementation of this Act, determine inherent weakness and loopholes in the law, and recommend the necessary remedial legislation, or administrative measures, and perform such other duties and functions as may be necessary to attain the objectives of this Act. Section 25. Appropriations. The amount necessary to implement the provisions of the Anti-Child Pornography Act, and the operationalization of the Interagency Council Against Child Pornography, shall be included in the Annual General Appropriations Act. Section 26. Implementing Rules and Regulations. The Interagency Council Against Child Pornography shall promulgate the necessary implementing rules and regulations, within 6 months from the effectivity of this Act. Section 27. Separability Clause. If any part or provision of this Act is declared invalid or unconstitutional, the other parts thereof not affected, shall remain valid. Sections, or provisions shall not be affected. Section 28. Repealing Clause. All laws, presidential decrees, executive orders, administrative orders, rules and regulations inconsistent with or contrary to the provisions of this Act, are deemed amended, modified, or repealed accordingly. Section 29. Effectivity. This Act shall take effect 15 days following its publication in 2 newspapers of general circulation. Signed, November 17, 2009. Prepared by the person, whom I admire everything about him, Taunton of Philim Band. Thank you for